When a family unit breaks apart, the emotional toll is obvious. But for dependents, the most immediate crisis is entirely financial. Almost overnight, the sudden loss of support can push a spouse, a child, or an elderly parent straight into vagrancy. Traditional civil lawsuits are notoriously slow, often trapping families in procedural delays for years. But people facing sudden abandonment don't have years to figure out how to buy groceries or pay rent. They need day-to-day survival. This chart shows how the state intervenes. Sections 144 to 147 of the Bharatiya Nagarik Suraksha Sanhita, or Bnss, offer a fast-track remedy. It's a summary legal mechanism designed to bypass standard court delays, with interim relief ideally mandated within just 60 days of serving notice. Crucially, this law cuts across all religions. The Supreme Court's ruling in the Mohammed Ahmed Khan v. Shah Bano Begum case cemented the principle that preventing destitution is a secular obligation, one that overrides individual personal religious laws. The core mandate of the Bnss provision is straightforward. If you have sufficient means, you are legally compelled to financially support your dependents who cannot maintain themselves. It operates as a rapid triage system for vulnerable citizens. By shifting the burden of survival back to the provider, the state draws a hard line in the sand, setting up a high-stakes collision for anyone who tries to dodge the bill. The true test of any maintenance law is how it handles evasion. When reluctant providers are ordered to pay, they predictably turn to technical legal loopholes to try and escape the obligation. The first evasion tactic attacks the definition of the relationship itself, with the provider claiming the dependent simply isn't their legally wedded wife. The Indian courts shut this evasion down. Rulings in Badshah and Chanmunia look past the paperwork. The Supreme Court expanded the law's protective umbrella to include women deceived into void marriages, divorced wives who haven't remarried, and partners in long-term live-in relationships. If that fails, evaders pivot to a second tactic, arguing that because the dependent earns a small income, they aren't technically destitute. But the Supreme Court clarified in Chaturbhuj v. Sitabai that unable to maintain herself does not mean absolute starvation. If a dependent's meager earnings fall short of allowing them to live a life of dignity, the provider is still legally on the hook to make up the financial difference. The legal framework actively prioritizes the harsh reality of a dependent's vulnerability over strict, outdated technical definitions of what constitutes a family or destitution. With the definitions of dependency broadened, evaders typically attempt a different angle, this time focusing on their own ability to pay. They invoke the third loophole, claiming they are currently unemployed and therefore possess no sufficient means. The courts closed this door as well. In the Shamima Faruqi ruling, the bench established that an able-bodied person cannot hide behind voluntary unemployment to starve their family. Sufficient means includes your earning capacity, not just your current bank balance. This leaves the ultimate evasion tactic. The provider ignores the court order entirely, or volunteers to serve jail time, assuming that will clear the debt. Under Section 144 of the Bnss, a magistrate can impose a month in prison for every month of default. But as highlighted in the Kuldip Kar case, prison does not wipe the slate clean. It is merely coercive. Arrears continue to pile up. Section 147 further ensures there is nowhere to hide geographically, allowing these maintenance orders to be enforced by any magistrate anywhere across India. The law architects an inescapable perimeter. Choosing voluntary unemployment or choosing a prison cell provides exactly zero financial escape route from this legal obligation. Of course, this stringent legal backing is not a blank check. Section 144 contains specific disqualifications to prevent abuse of the system. A maintenance order can be denied or canceled if a spouse is living in adultery, refuses to live with the provider without a just cause, or if the parties have mutually agreed to separate. It is a calibrated lifeline, not a tool for extortion. To understand why these rules are so unyielding, we have to look past the Criminal Procedure Code and look at the ultimate authority anchoring it, the Indian Constitution. These maintenance provisions are the direct realization of Articles 15(3), 21, and 39. They take what might be seen as a private moral duty and convert it into a strict state mandate for social justice. By enforcing these rules, the state guarantees a right to a life of dignity for all vulnerable dependents, protecting legally wedded wives, illegitimate children, and elderly parents alike from the threat of starvation. Personal relationships and family units will inevitably fracture, but when they do, the basic human right to survival is fiercely and inescapably protected by the state.